Wakili, what are the issues that you have presented before court to stop the court process in the case of the control of budget, Margaret Nyakang'o?
The control of budget, Margaret Nyakang'o was arraigned before the Mombasa Criminal Chief Magistrate's Court with allegations touching on 10 other people. I got instructions from the Member of Parliament from West Mugirango, where she comes from, Honorable Stephen Mogaka. I also come from West Mugirango. On pro bono basis, we went to court because that is our sister, that is our lady. And on behalf of the Gusii community that has been targeted by Kenya Kwanza, the issues that we took to court are constitutional. One, can a constitutional office holder be charged in a criminal court before they invoke Article 251 of the Constitution, which provides for mechanisms of removal of a constitutional office holder before that person is arrested and charged. This one, we relied on the precedents of the current Deputy Chief Justice. When she was arrested, that was the argument, and the court upheld that she cannot be charged until they invoke the removal of her from office. Number two, the same issue arose when some other judges who are my clients, Justice Mchelule, Justice Chitembwe, were also arrested and purported to be arraigned in court. The courts have spoken that a constitutional office holder cannot be taken to take plea before that has been issued. We have also raised the question of the attempted arrest and charging of the former Auditor General, Oko. So we have provided that the courts have pronounced itself that the state, if they want to remove, they want to charge somebody, they must first remove that petition. What does Article 251 say? File a petition to Parliament. Parliament looks at the 5 grounds provided for removal. If they are satisfied, they send the petition to the President, who will suspend or decline. And if he suspends, the President will appoint a tribunal. The tribunal will investigate Nyakang'o, and once the tribunal finds out that Nyakang'o has committed that offense, then she will be removed, then she will be charged with a criminal offense. That is the biggest constitutional right we are fighting, that if Kenya Kwanza is allowed to hound out constitutional office holders, then anybody is going to go home because they are not wanted, because their face looks bad, or because their nostrils are bigger, and they will be chased out of office. The second issue that we have raised before the court is the question of the inordinate delay. This is an offense that allegedly was committed 2015-2016. Nyakang'o Margaret appeared before. Nyakang'o Margaret, control of budget, appeared before all the entities of government that are supposed to vet: the DCI, the EACC, Parliament, NIS. All of them cleared this lady, and she was appointed and vetted by the President then as the control of budget. Where again do issues arise that are before? That is the second question. So we are saying there is a fishing expedition. There is a serious fishing expedition to get reasons to invoke Article 251 and remove Margaret Nyakang'o from her constitutional office. Third, we have also raised the question in the manner the harassment that the constitutional office holder was subjected to. Is it proper for a constitutional office holder to proceed like this one? So those are the three issues that we have taken to court, purely not based on politics, save that as a West Mugirango constituent, as a leader from the Gusii community, as a person who knows the law, we went to court to protect the integrity and the constitution of this country, because under Article 3, anybody can go to court to defend the constitution, and that is how my brother, Honorable Stephen Mogaka, MP for West Mugirango, went to court. Of great importance is that, remember, the only constitutional office holders from Gusii community is only Margaret Nyakang'o. She's being hounded office. All the people who are there were hounded out of office. None of the Gusiis has ever been appointed a PS. This is a government of shareholding. It is very clear that the Gusiis are not shareholders in this government. And therefore, we shall be moving. Because the question that I have gotten instructions from the Gusii community is to move to court to say that Gusiis should not pay taxes because they are not part and parcel of this government, and especially the Nyamira section. The other day, we saw how exams were marked, targeting the Gusii community. We have seen how parastatal heads have been chased out of office, targeting the Gusii community. We are now seeing constitutional office holders being targeted, targeting the community. So, as much as I'm an advocate of the High Court of Kenya, those are not issues I'll raise in court, but Article 27, which we have invoked, says that you cannot discriminate based on race or tribe. We have raised this, that the Gusii community is being discriminated based against and contrary to Article 27 of the Constitution.
What has been issued? The reaction that stopped
the independence of the judge, the independence of the judiciary will be the biggest bottleneck to Kenya Kwanza. The courts have stopped prosecution, which means up to May, and May is when we are going to do highlighting. Margaret Nyakang'o we shall be taking her back to the office tomorrow to resume office, because there is no prosecution that is in place. She will sit and discharge her mandate unless anybody who wants to remove her goes to Article 251. That is the only way to remove her and prefer charges against the state.
So what happened on Tuesday was an illegality?
A total constitutional illegality, a total constitutional rape, a total constitutional hemorrhage. It has never happened anywhere, and courts have always stopped. And that is why they arrested her, sneaked her to court. By the time we are getting instructions, she has been arraigned in court. Had we gotten these instructions, we could have stopped before she takes plea. But now that that plea has been taken, it is moot, it is academic. It has completely returned Kenya to a constitutional democracy where the rule of law is the king and is the queen.
Lastly, Wakil, you have argued in the court papers that have been submitted in court that this actually is a civil matter, should not be a criminal. Maybe a comment on that.
This dispute has nothing criminal. This is a dispute between two private entities. Nyakang'o that time was not a public servant. The SACCO, any matter about a SACCO, we have a court called the SACCO Tribunal that deals with disputes of SACCOs under the SASRA Act. If dissatisfied, we have the commercial courts that deal with civil matters and debts that are owed. The DCI has no role on civil matters, and that is why immediately after this I'm writing to the DPP tomorrow to recall that file, look at that file and find out that no criminal act was committed, and therefore terminate those matters, that case, because it was kept in secrecy. I'm sure the good office of the Director of Public Prosecution was not given full information. It was misled. Tomorrow we will provide proper account to account, and the DPP knows very well that at Section 87A will always apply. The same Section A that was used to terminate cases of my Deputy President Gachagua, the same Section A that was used to drop charges, we will be going tomorrow writing to the DPP that this matter is causing a lot of unnecessary attention. We withdraw these matters, and there is precedent that many